So good afternoon, everyone. My name is Jason Hanford. I'm an attorney at Chartwell Law. If you're seeing and hearing me today, it's because you signed on for our final in our series of Pennsylvania Workers' Comp 101 courses. Today, we're talking about settlement and mediation strategy. So before we get into anything specific or general, I want to remind everybody that these are, we call them 101 courses. They're overview courses, broad overview courses. As with lots of things you go through in life, your 20th time is somebody else's first time. So we're trying to communicate what happens with settlement mediation to somebody who maybe hasn't done it before. So some of the stuff you're going to hear today, and I see some of the people in the attendee list know a lot more about workers' comp than I do. So you're going to hear stuff you already know, but hopefully it's a refresher. Hopefully you hear some stuff you don't know. If you're bored to death, I want to give a preview. Now that we're done with the 101 and we've taught you everything you could possibly know at the entry level of Pennsylvania Workers' Comp, our next series of presentations is going to be the 200 level courses. So I can see the excitement in the crowd already. We're going to go and touch on the things that we couldn't touch on before. So we'll go through a lot of these presentations. We'll talk about claim petitions. We'll say, well, that's something we could spend an hour on. And then we give you 10 minutes on it or 5 minutes on it and we move on. Now we're going to spend an hour on it. So that's what the 200 level courses are about. I think the first one's going to be in May. You'll all get an email explaining what they are, giving you the schedule, and hopefully you'll come back and join us for those. I think it'll be a good exercise for all of us. The usual instructions that I give in these seminars: number one, we're not providing specific legal advice today. We're giving a general overview of Pennsylvania workers' compensation law that we hope informs you in what you do in your job. If you have specific questions about specific claims, you need to talk to your own attorney. Hopefully that's us. If it's not us, it can be, but make sure you discuss with counsel any specific legal questions you have. Don't go making any bad decisions based on my bad jokes today. If you have any questions, and questions are already coming in, this is exciting. If you have any questions throughout the course, there's a bubble at the bottom of the screen. I have to move mine. It's entitled Q&A. There's also one chat, so I see questions in chat and Q&A. That's all right. We'll get them all. Put your questions down there. We'll get to them as the seminar goes on. If for whatever reason we cannot get to your questions, I apologize in advance, but we will follow up with you on email. All of our videos, they're going to be on our website. They're going to be on YouTube. If you want to watch them at some other time, if you think they're so good that they could train somebody else at your organization, go ahead, share the videos. They'll be up there in perpetuity. Maybe you can use them for torture purposes or if you need to go to sleep. Anything else that you want to ask us about that you don't want to share publicly today? I think our contact information will be shared at the end. You can always email us. You can always call us. All three of us are readily available now and forever, and we're very responsive to any questions. Getting that boring stuff out of the way, let me introduce my co-presenters, the experts today. I'll start with Jacqueline Vitero, who is from our Valley Forge office. Jacqueline is a partner at Chartwell. She practices Pennsylvania workers' compensation in an incredibly capable and competent manner. She's loved by all our clients. Jacqueline, can you say hi to everybody?
Good afternoon, everyone. Thanks for joining us.
And from Harrisburg, the middle of the state, we have Rob Baker. Rob Baker's been at Chartwell longer than I have. We've been working together forever, Rob. And I think you did one of these seminars with us before too. So welcome back.
Yes, thank you.
Good to see you. And we're excited. We're excited to move on. So all of that excitement out of the way, I see several comments about whether we're going to have continuing education credits for the 101 level. The answer, as I see Chartwell Law, my good friend, has already answered, is that this particular course is not for CE, but it's something that we can do. It's something that we've done in the past. And if there's a lot of interest in it, I think it's something we can consider for the 200 level courses. It's an organizational thing that we have to put together. And as you know, if you do the CE courses, we have to read off a special code in the middle to make sure you're not cheating or you didn't fall asleep. But we'll definitely take that into consideration going forward. And I appreciate that question. All right. The general format for this is I ask questions and then the experts, which today are Jacqueline and Rob, answer the questions. And we have what best passes as an open conversation. The only part where I will take over the conversation is now, when I can't stop talking and when I do the introduction. So I will now do the introduction. We're here today to talk about settling the case. how did we get here? Specifically, a Pennsylvania workers' compensation claim. How did we get here? We already talked with you about claim petitions. We talked about accepting an injury if you don't want to have a claim petition. We talked about what happens if the claim is lost. If you have a compensable injury, how do you get out of the medical exposure? How do you get out of the wage loss exposure? We walked through all of that. We talked about all the forms that you have to issue along the way. And now today, we're going to talk about what's really the last tool in our tool bag, settling the case. So you've tried to close out the wage loss and medical exposure. You've tried your termination petitions, or frankly, maybe you haven't. Maybe you've decided that instead of spending the money on that, it's going to be quicker and easier to settle out the claim with a settlement. So how do we do that in Pennsylvania? To get to where we are, we talk about where we were. The way it used to be was we had commutations in Pennsylvania. That was before all three of us were practicing, I believe. But the commutation was essentially the law of the land forever. And what that meant was you could petition to a judge to go before the judge and essentially pay off the claimant for the wage loss benefits that they were due throughout the remainder of their claim. It was capped at 500 weeks. So if the claimant's owed another 400 weeks, you could pay that 400 weeks off in a lump sum. You get a reduction in present day value of a certain percentage. It might have been 5%. And that's how you closed out the wage loss exposure. You couldn't close out medical exposure doing that. The judges had a lot of oversight doing that. And I think a takeaway viewpoint of it was it really protected the claimants from making stupid decisions. So if they had 300 weeks potentially left, it protected them from settling out for 5 weeks or something of that nature. All of that changed with Act 57. We've talked about Act 57 a lot in our prior seminars. You probably picked up on the fact it was an important legislative piece in Pennsylvania. That was in, I think, 1996, 1997. And with Act 57, we got the compromise and release in workers' compensation. The compromise and release in Pennsylvania workers' compensation essentially allows you to settle with freedom. It allows you to make stupid decisions on both sides, as long as, and this is what we'll talk about a little bit later, the judge determines that the claimant understands what they're doing. The claimant can settle for 5 weeks. They can settle for 200 weeks. They can also, perhaps most importantly now, they can settle out their medical exposure. So I would imagine most of the people in this presentation, most of the attendees, that's the world you know the compromise and release world. And that's what we're here to talk about today. So I want to start with you, Jacqueline. Hello again. Before we go to the judge to get the CNR approved, we obviously have to figure out what are we talking about? What kind of settlement monies are we talking about? So we want to start with assessing exposure. And this is not something you do the day before the mediation, right, Jacqueline?
That's correct. When you're assessing the exposure, basically you're looking at all information available to determine how likely a claimant will receive or will continue to receive benefits and for how long. And generally speaking, we value cases based upon an individual's temporary total disability rate. But instead of speaking in terms of weeks, we usually refer to settlement in terms of years. So if an individual has a temporary total disability rate that ends up being $10,000 per year, we'll often say we recommend authority of 2.5 years, which is $25,000. That's the general rule on how you value it. But of course, there are exceptions when we do step away from that. For example, if there is significant medical treatment that needs to be taken into account as part of a settlement. But generally, we're referring to settlement in terms of years. But like you said, Jason, we are prepping and preparing to provide our settlement recommendations pretty much from the day we get a file. Once we do have sufficient information to assess the value of a case, we will move forward in soliciting a demand from the claimant's attorney. And when we do that, we're also asking for more than just the demand. We're asking for things like if an individual is a Medicare recipient or eligible. We're asking if there's child support orders outstanding. We're asking if there's any kind of third-party litigation or if there's any medical liens, because all of those things are things that we will ultimately need to address in the settlement paperwork if we reach an agreement. So we want to make sure we have complete information as early as possible so we can fully gauge the value of the case. In doing that, one of the things that I feel comes up most commonly and can be a pretty big issue is outstanding medical bills. A lot of times we'll get a demand that is a lump sum payment of, let's say, $100,000 plus outstanding medical bills. There can be scenarios, for example, when a claim is in a denied status, or perhaps if we are alleging or disputing an injury. So the accepted injury is to the back, but there's a disputed injury to the leg. In those scenarios, there might be significant outstanding medical bills. So we're going to make sure we get that information from opposing counsel so we fully can assess what their demand is, what the cost of the case will be under various scenarios of resolution. To get the outstanding meds, my personal preference is to get that information from the opposing counsel. They often have the better relationships with the providers to get that information a bit faster. But there will be times where I reach out to the adjuster and see what kind of denied bills they have in their system. But anyway, once we get the demand, I'm going to then work on my settlement recommendations. And there's a number of different factors that I'm going to take into account in providing my recommendations. And I'm going to spew some off, but they're really not in any particular order. I'm going to look to see if the defendant, the employer, is currently paying any benefits. If so, what are we paying? Are we paying medical and indemnity? Are we just paying medical? Is the claim denied entirely? And the status of the benefits is important to determine what we're already obligated to pay and what we could potentially be obligated to pay in the future. So we're going to use that information to estimate the overall exposure. Other things that I'm going to look to is if a case is in litigation, what kind of litigation is pending. Depending on what is pending will also impact the value of the case. So if we are, for example, alleging that the benefits should be terminated and we have a full recovery opinion, we may be able to assess a lower value on the case as opposed to if we are only litigating a review petition. Let's say we're fighting over the description of injury, but we have no petitions pending, such as a modification, suspension, or termination petition that could potentially end benefits. So the actual petitions that are pending, if any, will impact the value. I'm also looking to some general information like the claimant's age, the general overall severity of the injury, the overall health of the injured worker, even separate from the work injury. And I'm also going to look at the post-injury medical treatment. So for example, if someone is 22 years old and they sustained a finger laceration, that value is probably going to be much less than if someone is 60 years old and sustained a disc herniation that required surgery. So basically what I'm doing is I'm just trying to gather some factual information to estimate the ongoing exposure of the case. And also age is important for a couple other reasons. Age is important because it could be a sign of a Medicare issue that we would need to take into account. And age could also be important to determine if there are any kind of Social Security retirement offsets that could be available in the future, which would again impact the exposure of the case. And in that same regard, if it's in litigation, I'm looking to who the assigned judge is and the likelihood of success in whatever we're litigating. We all know that some judges are more claimant oriented than others, so I want to take that into account in estimating how likely it is that we will prevail. And basically when I'm doing that, I'm looking at all evidence, all factual and medical evidence that either has already been presented or could be presented, and coming up with a percentage of likelihood of success in whatever it is we're litigating so that we can really estimate, again, the future exposure on the case. And then some other things that I'm looking to is what future options do we have available to potentially argue for a modification, suspension, or termination benefits in the future. For example, can we get an updated IME? Do we anticipate a full recovery opinion in the future? Are there permanent restrictions that we need to take into account? Can we extend a job offer? Basically, what tools do we have to potentially argue in the future, even if we don't already have them, for a reduction of benefits? And another big thing that I look to is if we're in litigation, where are we in the litigation? What kind of litigation expenses are going to come about if we continue to litigate and take this decision? These costs include not only paying the attorney, but also the expert fees. The deposition fees for medical experts seems to be going up every year. And so if we're settling it now, perhaps we're going to save $6,000 on a debt fee. So these are all things that I'm going to gather, and based upon all this information and basically all the factual information that I have, what I want to do is then determine a value for the case that if we settled, it would result in a cost savings to the employer as opposed to leaving the case open and continuing with the litigation.
Yeah, and I think just listening to your discussion there, Jacqueline, I like the idea of starting early, because I think that the longer you wait, if you wait until the week of the mediation to start looking at these factors, you're either not going to be able to get the information, because it does take time to gather some of this stuff, or you're just not going to be able to work through it efficiently enough. You might not be able to get authority in time. And mediations are an opportunity to close out the case. Sometimes it's an opportunity that you're not going to take advantage of for good reason, but a lot of times it is, and it's a good way to close out future exposure. I think one thing for any new adjusters or claims handlers on the call that can take some getting used to with regard to Pennsylvania claims is what you've paid so far in the claim doesn't necessarily dictate what you're going to pay out in your settlement. And that can work both ways. You could have a claim that's been around for 6 years and you've paid a lot, but for whatever reason, based on the scenario you're in, you've offered a job now, you've gotten out of a certain medical treatment, you might be able to close that out for less than you might think. It also works in the other direction. You might be 6 months into a claim with a severe injury, somebody who's already on Medicare, and you might not have paid very much now. And Jacqueline or Rob might come to you and say, you know what, you should settle this. You should settle it tomorrow. You might have to pay 2 or 3 years to get it done, but in the long run, you're going to save money. That can be it's not commonsensical necessarily at the outset, but I think you're going to see that in more and more claims where you're looking at future exposure. You can't worry as much about what happens in the past. But one thing that I like to ask for, and Jacqueline mentioned it too, is I always like to get a medical payment ledger. Obviously for a newer claim, it's not as much of an issue, but for any longstanding claim, I want to see the medical payment ledger to gauge what's been paid in medical, also to identify things that might have been missed, because we often see as we get to the door with settlements, somebody pops up and says, hey, this bill was never paid, this surgery was never paid for, health insurance paid for this, Medicare paid for this. If I know that claimants had 3 spine fusions and I look at that medical payment ledger and the carrier's only paid $20,000 over 3 years, then at least I know in advance that that's potentially an issue. And that's not something you want to find out about, a couple days before the CNR hearing. Rob, can we ask you questions too?
Yeah, I actually had a few unsolicited comments. So
those are my favorite. No
yeah,
cursing,
so
but anything else.
I definitely do everything that the two of you do. The one thing that I always look at is what is the nature of the petition? And some of this is geographically based, right? So in my practice area in Western Pennsylvania, many of the judges will allow an employer-driven petition to go to decision, and then you're essentially settling future liability. Say it's a termination petition, and you're litigating full recovery. I do that because you've preserved the superseding estate by filing a termination petition, and it's easy enough to calculate, at least on the wage loss side, what the potential supersedious fund reimbursement might be. So if you settle a case, say for $70,000, you may well have a claim where you get a portion or even a larger portion of that amounts as a supersedious fund reimbursement. There's a few factors for that. One, the judge has to be willing to allow the decision to proceed. I know my experience has been that a lot of the Philadelphia, Southeast PA judges aren't in favor of it, notwithstanding the fact that it's completely legal and the law's in our favor. So the judges are a factor. Two, it's also, I think, a factor with opposing counsel of whether or not they're going to allow such a petition to proceed, because it may impact whether they have a subrogation case. It may impact their eligibility for Social Security disability benefits in the future or something to that effect. But that's always something that I like to look at, because it's a good way to net down the settlement, in other words, because you might pay something through the workers' compensation CNR, but at the end of the day, you might get additional reductions through supersedious fund reimbursement. I think it's important to note too that the ranges we're talking about, they're not hard and fast settlement ranges. This is an art form as much as it is a science. It's just, I think, over our collective experience and the experience of our colleagues on the dark side, that these are the parameters, generally speaking, for typical or similar claims. There's always outliers on each end, but generally speaking, the ranges that we're talking about are fairly consistent. I think one factor too is what is the length or the age of the claim? Because if someone is coming up on an IRE, or they are already running the clock on the 500 weeks for the IRE. I think that is sometimes a factor too, because that if someone's receiving 500 weeks on the impairment rating, that is the end game, so to speak, for potential wage loss. The other side of it is, I guess, if you have a negative IRE where the rating is over 35%, you have potential lifetime exposure. So that would certainly, I think, increase the value of the claim when you're looking at the settlement parameters. The one thing I like to do, especially on disputed cases, and I have a few clients that mandate this, if we're going to resolve medical or pay any medical as part of settlement, of course, you can pay medical bills without an admission of liability on a compromise and release agreement. But if we are to pay medical, my clients, by and large, on a disputed claim, they would like an itemization of what medical bills are being paid, because that the parties have agreed to that, because they don't want on a disputed claim, or even an accepted claim for that matter, to get a bill, a year, 18 months later, where they have to reopen the claim and pay the bill. So that's something else that I think we collectively try to do, is itemize those bills and liens as well, to the extent we can. I've had cases where the claim has been disputed. There are outstanding medical bills, and claimants counsel has negotiated directly with the providers a reduction on the bills that are being paid that's below the Act 57 repricing. In that situation, I would like to submit documentation from the provider and opposing counsel that they did all the negotiation and they are the ones that came to this agreement, and that the providers accepting those payments to satisfying the outstanding medical bills. But other than that, I generally do everything that the two of you have been discussing.
Awesome. Rob, I neglected, I think, in my introduction to explain that Rob is also our go-to guy for employment law at Chartwell, both as a plug right now, but also as a lengthy lead into my simple question. Rob, we're talking about exposure things. We're talking about, money. That's what we're talking about today with settlement. But with a self-insured employer, and probably even more so with a insured employer, where you're dealing mostly with the carrier, the employer still exists, and occasionally they'll pop into the settlement discussions. I'm interested on your take from your experience with employers, working in that industry and representing employers in the legal industry now. What pops up with the employers that you've seen more than once that it might be good to be aware of if you're an adjuster or an attorney involved in settlement and valuing a claim?
Sure. Well, I think first and foremost, generally speaking, employers don't want the employee back to work. So part of what we're doing, and there are outliers, certainly. I mean, there are situations where maybe there was a specific loss case and the employee is entitled to the scarring anyway, and the employee's back to work, but you can close out additional medical. That might warrant a compromise and release agreement without resignation. But by and large, the claims that I work on, the employer and or the carrier would like to obtain a resignation of employment as part of settlement. That technically is outside the scope of workers' compensation. But in Pennsylvania, I think it's understood more or less that again, by and large, that that's a throw-in from the claimant's bar, that they understand if they're going to settle the case for $100,000, that the employer is not going to want them back, especially if that employer is still on the same risk with the carrier that just paid the $100,000 settlement. So yeah, that's the one thing that we look at, is the letter of resignation, and we always want to be upfront with respect to our position on resignation and general release agreement. And I'll get to the release in a second, but I think again, we have to get into the geographical issues, because I know in the Southeast, the judges do not generally look favorably upon negotiations that include a resignation without separate consideration. So that leads me to my other point, where I recommend to clients, regardless if they're self-insured, high retention, or fully insured with a lower retention, that they strongly consider looking at getting a general release agreement. The general release agreement protects the employee from, or the employer, from other lawsuits, FMLA lawsuits, wage and hour complaints, EEOC, any of the employment alphabet discrimination cases. It doesn't have to be a lot of money. I typically recommend $100, but the important part is that the employer has to pay for the consideration. The consideration cannot be the workers' compensation settlement. By law, it's not, workers' comp isn't taxable. Technically, portions or all of employment settlements are taxable, but the consideration needs to come from the employer directly. There are cases where employers, especially if they're self-insured, say, well, we just want the carrier, the TPA, to pay for the consideration. I tend to recommend otherwise, because I still think that even though the employer is funding the self-insured mechanism, there could be an argument made by claimant's attorney that the consideration was inadequate. So what I like to do is I get a W-9 from the claimant. If the client wants the general release agreement, send the W-9 to the employer. The employer cuts a check for $100. I like to make sure that it gets there, so they'll send it to me, and then I return that with the executed general release agreement and the check to claimant's counsel. So we have it documented if it had flowed correctly. But the resignation, you can get it. I think it's super important in Pennsylvania to make sure that you as either the employer or the TPA are protecting everyone's interests. One issue that comes up, though, is on the insured side, where the policy doesn't cover the employment component of the case. So the claims professional, the adjuster, might advise that that's outside of the scope of the representation for what we're doing on the comp side. That's easy enough to remedy, though. We would just simply, if the employer wants it, we contact the employer, and we would handle that portion outside of the scope of the workers' comp file. Other issues that come up is, oftentimes I'll see that if it's a mechanic, usually mechanics pay for their own tools, so they might have a very expensive toolbox sitting at the shop, or they might have keys or a computer or something to that effect that needs to be returned. We try to address all of those ancillary issues as well to make sure that the equipment is returned before the settlement. I think that if you're going to try to get employer-owned equipment post-settlement, that might be a little difficult. So it's not necessarily legal work, but I usually try to put the claimant in contact with counsel's permission, of course, with the employer to coordinate that return of or exchange of equipment to make sure that is handled outside of the workers' comp claim, and that issue is addressed before we go to the settlement hearing.
Yeah, I think, and I think baked into everything that Rob said is to me the underlying recommendation or overarching recommendation to make sure you have good communication with the employer in every claim, whether it's an insured employer where you're working through the TPA, whether it's self-insured, whatever the situation. Employers are people, and sometimes they'll be over involved. Sometimes you'll never hear from them at all. But I'm sure everybody who's settled comp claims in Pennsylvania has had employers that they didn't hear from until they saw what was going on with the settlement, and they were concerned because it's a lot of money and there's zeros, and those are their premiums that they're going to be paying for comp settlement. So keep that line of communication open. That way you can address all of those things that Rob mentioned. I've had CNRs blow up in the hearing room because the uniform was not returned or the tool was not returned, and that's never something you want to happen. The judges don't like it, and it just ends up costing people money. So I think keep that line of communication open, keep those things that Rob mentioned in mind, and that way they don't come back to bite you later.
Jason, I get a lot of phone calls too when, as you're saying, the employer isn't necessarily aware of what's occurring. And the call I get is, well, how's this going to affect my premiums or my mod rate? And I have to very politely say that, that's above my pay grade. You need to contact your agent or the insurance carrier, because that we don't have that involvement. So to the extent that they're surprised, it does at times make things more difficult.
Sure, and it's an understandable concern because if somebody's doing what they're working in whatever their trade is, and they have 20 employees and they maybe have one comp claim every 10 years. Some of the numbers that we see in these cases can be, I'll call them offensive. And if you've not seen much of anything with regard to what's being paid because you're fully insured, when you see that final number, it can cause some anxiety. So it's just be aware that might come up and keep the communication open, get that person to talk to the right people to address their questions. I want to make sure we move along. Rob, I have you down to explain to everyone what MSAs are and how they're involved in settlement. This is one of those 200 level topics that I'm asking you to give us a minute or two on. How does an
Okay,
MSA pop up?
I have it boiled down to less than a minute. So if somebody is a Medicare beneficiary and the settlement is greater than $25,000, you have to obtain what's called a workers' compensation Medicare set aside. It's a fancy way of saying that it's a life care plan, medical document to determine the potential medical exposure for the claimant for future medical treatment for the expected life duration. That document is then submitted to CMS for approval. The other scenario is if the individual is not a Medicare beneficiary, but there's a reasonable expectation that they would be enrolled in Medicare within 30 months and the settlement's greater than $250,000, you have to get the MSA. Why is that important? Because CMS they have a super lien status, so they can pursue the carrier, they can pursue the claimant, they can pursue defense counsel, they can pursue claimant's counsel to ensure that their rights are fully protected. The MSA is essentially then an allocation, a payment if an MSA is required in the compromise and release agreement. There's a line item that notes the amounts of the money allocated. And if there is an approved CMS determination, that would be attached to the compromise and release agreement as well. That money then has to be used by the claimant, whether it's funded by a lump sum or an annuity for future medical treatment until it's exhausted. The employee has to keep record and provide documentation for the medical treatment. If that process isn't followed, Medicare can deny medical treatment to the claimant for that condition until the CMS concerns are addressed. From our perspective, it's very important to make sure that we comply with the Medicare guidelines and identify for you as our clients when there's a Medicare issue. I've had cases where the claimant has denied that they're receiving Medicare or Social Security disability. Their attorney asks them on cross-examination, and one of my standard questions is asking about Medicare and Social Security disability. And then they suddenly remember that they've been receiving that benefit for 5 years. So it comes up from time to time, but this is, as Jackie had said, I think at the outset, Social Security disability and Medicare status is something that we want to identify as soon as possible because it does impact how we address the claim, how we're going to close out medical, and the exposure, quite frankly, of the claim if we have to address Medicare funding. With respect to funding, the claimant's bar, claimant's counsel will certainly almost always, 99% of the time, require that the defendant fund the MSA as part of settlement, unless the MSA is very, very small and we've negotiated a larger settlement, and then in those cases the claimant might fund it. But that's another reason why we want to know at the outset what the Medicare status is, because we don't want to have a situation where we request a settlement authority, we go to mediation, and then we learn that there's a Medicare issue or a Medicare lien that needs to be addressed for conditional payments. So it comes up, though. I mean, that happens, and one of the things about our practice is we have to be able to change lanes and shift gears and address things as they arise. Conditional payments are related to Medicare. So in the event Medicare pays for workers' compensation treatment related to the work injury, those are conditional payments, and those need to be reimbursed by the self-insured entity or the carrier if there's a conditional payment issue. And that's also addressed in the compromise and release agreement.
That was good. That was a long minute, but that was
yeah, it was like 3. Okay, I get that, but it was the best I could do.
That was a good, fantastic overview. We'll have Rob, since he just volunteered, do the 200 level course on Medicare.
Happy to do it. Happy to do it.
My own walkaway points are the black and white areas regarding Medicare set-asides are none. It's a bunch of gray uncertainty and the classic "it depends" attorney responses. Number one, and number two, the potential presence or need for a Medicare set aside in the future might be a reason to consider settling now when you don't have to deal with it and settling early in the claim. And perhaps it might be one of those cases where you haven't paid much, but I'm asking you to pay more when you settle so we can avoid this kind of thing. So come back for the MSA section. I think we had a Q&A question that we might be talking more about this later, but we got to move on. We got to talk about mediation. Jacqueline, I want to ask you, just to set the table, we can pursue in Pennsylvania voluntary mediation, where the parties say, hey, we want to mediate. We want to mediate with Judge Bob, Judge Sally. We submit the request on WICAS and we set up a mediation date. Or throughout the course of litigation of the claim, the judge can order mandatory mediation, assuming it's not futile, in which a judge is assigned by the Bureau. For either of those scenarios, I don't think it really matters which one we're going into. You're meeting somebody at a cocktail party. We're now having those post-COVID, and they want to know, they heard, Jacqueline, I heard you're a comp attorney and you go to mediations. That sounds awesome. Can you tell me what happens on the day of a mediation? How does this all work?
Well, first I would tell the person to get a drink because it'll make my story more interesting. But basically the mediator is a neutral party. They are not the judge that's going to be deciding the case. And the goal of the mediator is just to really talk to the parties and see if they can either get the parties to reach a global resolution of the claim or to reach an agreement with even like very small specific aspects of the claim. Perhaps everything is disputed and we can't agree on anything, but we walk away agreeing to an average weekly wage issue, something along those lines. But basically what the mediating judge does is they tend to start the mediation by having the parties all together. And when I say it's the parties, it's most commonly claimants counsel and defense counsel. That's at least where I practice. Rob's might be a little different, but on the eastern part of the state, that's usually the parties that are involved. And usually the mediating judge will just have everyone sit down. If we're in person, it'll be in a room. Otherwise, right now, it's still on Teams. And the judge will just go over some basic facts of the case. They'll talk about just what's pending. Perhaps they'll talk about average weekly wage issues, just making sure that they have all the correct information. They'll also ask the claimant about Medicare issues, about letter of resignation issues, outstanding meds, just real quick basics about that. And then basically what the judge does is they go back and forth from room to room to see if they can get the parties to reach an agreement, like I said, to either resolve the case in its entirety or just maybe perhaps some specific issues that are pending before the judge.
How long does it usually take, Jacqueline? Is there a set time?
I would say usually an hour is usually what it takes, sometimes greater, sometimes less.
Okay. Rob, do you like to have your client go with you, participate live in the mediation? Do you find that's productive all the time, some of the time? Do you have
my experience has been that it's not necessarily productive. And I say that because, especially if it's the employer, right? So if the employer is angry with the claimant or the claimant is angry with the employer, it seems to be, or tends to be counterproductive because they just vent their anger to each other. I think that mediation is a good way for the claimant to cleanse their soul, so to speak, to the mediating judge, to get the weight off their shoulders about why they don't like the employer. So no, I generally don't. I mean, the employer is certainly welcome. I have some employers that like to participate, especially those that are maybe more sophisticated than others. But it's certainly not required. We were talking about this when we were preparing. But one of the trends that I've been seeing in my area, Central Western PA, is the judges have been all but demanding that either the adjuster or someone from the carrier is available and participates in mediation. And I do give some pushback on that because there's nothing in the act that requires the carrier, the TPA, or the employer to participate. We're there on their behalf. So I get pushback on that. I think that some of the judges are starting to do it to try to strong arm settlement, which is again contrary to the plain language of the act. The act doesn't say you have to settle. The act says you need to negotiate in good faith. So I have seen that issue, and that might be one of the geographical issues that you see coming up. But I generally like to handle the mediation unless there's a reason to have the employer. If it's an issue where I've submitted my mediation statement and there's a dispute as to the scope of the job offer or the ongoing availability, or if it's a dispute to the claim and the claim might have a factual issue that would be helpful for the employer to be there to explain to the mediating judge of how this is physically impossible for the employee to have sustained the injury that they're alleging. Those situations, absolutely. But if we're on a claim that's been accepted and we're trying to terminate benefits, the contribution is smaller, I think, in that situation from the employer. But again, if the clients I'm working with and the files I have, if the employer or the carrier wants to be there, they're certainly more than welcome. But I find that generally, more often than not, they elect not to participate.
Jacqueline, are the judges you deal with, Eastern, Southeastern Pennsylvania, requiring more so client participation, and do you have a preference yourself?
They do not require employer participation. I tend to think that a lot of the mediating judge wants to keep the process as quick as possible. And so they almost see the employer as another person that they need to explain it to. Even it doesn't matter if the employer is sophisticated or not, they still just feel like they need to explain to the employer what's happening in the same way that they're explaining to the claimant. So I find that a lot of the mediating judges, they want to go as quick as possible, so they don't need the employer there. My preference is similar to Rob's. If there's a particular reason, absolutely sure. But otherwise, what we kind of already touched upon, the goal is to have the foundation already built, that by the time we go to mediation, we've already covered all the issues with the employer. So we already come equipped and ready to discuss the case in a meaningful manner.
Yeah, I think that's good advice. I think in my own practice, I have clients, I have some clients that want to go to all the mediations, which I have no problem with. I have some clients that don't want to be involved and don't want to be put on the spot like that. I would say when I would encourage the reluctant ones to participate is either in a big exposure case where the claimant's being completely unreasonable, and I can sit there with my client and say, Judge, we're here with a big pot of money. We really want to close this out. We're coming with honest intentions. Or I love you guys, all the people but sometimes my client and I have a different view of the claim, of the claimant, of the exposure. And sometimes it helps to have them sit in a room, sit in square boxes like the Brady Bunch, like we're doing today, and see that claimant and see how that claimant interacts with the judge. I'd prefer it's the trial judge, because then they can see if the judge is being more favorable to the claimant. But even with the mediating judge, they can give the client a hopefully objective viewpoint on, we know why you view the claimant the way that you do, but this is how they're going to be viewed in the legal process. And I think that can be helpful because it's hard. It's hard being on the claims management, claims adjuster side. You see all of these claims, you have all of these really expensive medical treatments, and you're paying out all this money. And some of them you get that sense about. And we understand that, but sometimes even when you have that sense about the claimant, you're gonna have to pay them money. And it's a tough thing to do. And sometimes it helps just to see how the process is unfolding. But I think that's a pretty good overview of mediation. Any mistakes that you guys see, either in preparing or on day of, things that you try to avoid that have happened in the past or that hopefully will never happen?
I'll start. I'll just say that generally speaking, it's not having those communications with claimants counsel beforehand. So there are information that's missing. For example, you didn't know that there was a Medicare issue, so you don't even know what the proposed MSA would be. And so it's hard to say to your client, yeah, go fund this MSA, because we don't know what that value is. Like same with outstanding medical bills. If we don't know what they are, it's very hard to even negotiate anything about it. So I think that just the brief summation is that not having the adequate information, not speaking with claimants counsel beforehand to make sure that you guys have as many issues or the information for many issues available at the time of the mediation.
Yeah, I don't know that it's a mistake necessarily, but I think it's important to know your parties. I think it's important to know your mediating judge and his or her style and opposing counsel. And I say that because some judges, they'll ask you, well, how much money do you have? We got to get this done. What's your max? And then they'll go to the other party and ask, what's the minimum he's willing to take, and if the numbers match, then the case is settled. So I try not to tip my hand in any fashion, so to speak, when I'm mediating. In fact, I tend to be rather aggressive with authority and have discussions with my clients. Say, I think this case is going to settle for 50, but I want 35. I want you to expressly tell me I have 35,000 for mediation, because then I can go to mediation and look at the judge, whether it's in person or in Brady Bunch land, and say, judge, counsel, I have $35,000 today to get this case settled, and that is on occasion a very effective way to get the case settled. And I also think that it's important for our clients to understand that when they see a demand, if we're equating it to years, if they see a demand of 7 years of benefits, that they shouldn't throw up their hands and say, well, we're not going to go mediate because they're being ridiculous. I try to remind the people I work with, their job is to start really high, we start really low, and then we try to meet somewhere in the lower end of the middle, to get the best settlement that we can, because they want to come in shooting for the moon, and we don't want to offer as much of anything as low as possible. So clients shouldn't be frustrated by the astronomical initial demand.
Yeah, as you guys were talking, I wrote down 2 notes. I wrote down bad judges. Hopefully there's no judges on here. There are no bad judges, but I wrote down bad judges anyways. Bad judges for the situation, and bad information. And what I mean by that is we're all going to know judges who may overvalue, in my opinion, a claim. And depending on the claimant, and you'll know the claimant by then, hopefully, that can be very, very bad, because once a number comes out in a mediation, especially if a mediating judge says, well, that sounds reasonable, it's hard to get the claimant to move off those numbers. So sometimes, as useful as mediation can be, sometimes you might want to not use an assigned mediator, a mandatory mediation. You might not have authority at that time. It might be futile, or you might want to consider very carefully who you're choosing for your voluntary mediation, because you don't want to plant numbers in the claimant's head that you're never going to settle for. Bad information.
The same could be true on the defense side, though, too, Jason, right? Because if we go to mediation and the judge says, well, the report back that the judge said the value was X, and our client might then say, okay, well, we're not going any farther beyond X because that's what the judge told us 6 months ago at the last mediation, but the facts have changed. I think that it's really important to find the best mediator possible to avoid any of that miscommunication on both sides.
Yeah, that's a good point. We don't have an abundance of judges underestimating case value in Eastern Pennsylvania, but
Yeah.
it does happen. And then
Not here either. I'm just saying that happens.
Yeah, bad information is kind of related to that. What I mean by that is a lot of times we deal with all kinds of different plaintiffs firms, claimants firms throughout the Commonwealth, and some of them are one-stop. One attorney handles everything, and some of them have 20 attorneys who bounce cases around. They don't always know exactly what's going on in the claim, and there's going to be information when the judge is talking just with claimant's counsel and with the claimant. There's going to be information brought up with that judge that a lot of times is just inaccurate. It's the claimant thought something, they thought something was compensable, they thought some treatment was going to be paid for or whatever. They'll put out information to the mediating judge that their attorney, honestly doesn't know is incorrect. If we, on the other side, if the defense attorney, if the claims adjuster haven't prepared for that mediation, you don't have all your information in a line, as Jacqueline's saying, you don't know all the outstanding medical bills, you don't want to concede that is an issue during the mediation, because then you're allowing the claimant to paint the picture of what the exposure is, and the mediating judge starts to side with the claimant. So I think you always want to have as much information and the correct information, because the last thing you want to do is have the judge endorsing a demand that's based on bad facts, because then that's stuck in the claimant's head and you really haven't accomplished anything. Anything else on mistakes or pointers on mediations before we move on, guys?
Just one last thing, and I think it goes to what you were saying. I think all judges at this point require some kind of mediation disclosure statement. Judges have different forms of how they like the information and whatnot. But, as defense counsel, that is something that I think is imperative. And it goes to what you were saying, Jason. It's our way of telling our narrative to the mediating judge. It's our way of making sure that our argument is out there. and that our position is heard even before we walk into the door. So I think it's very important that we have that done. And a mistake would be then to not have that submitted, which us at Chartwell, we would never do that, but it could be a mistake that comes up.
Yeah, mediation memos are important. I try to send them to my clients too, so that they can see how I'm assessing the case, and then they can see an honest assessment, because I want to give the judge the most honest assessment I can, and I want the client to see how we're communicating that to the judge, and I want that as a final, a checkpoint where the client can say, hey, you know what, I don't agree that treatment's going to come in here, or I don't agree that this is a factor that we need to consider for future exposure. Work that out in advance when you can, because you don't want to be doing it during the mediation.
Yeah, the one thing I do not put in my mediation statement is my evaluation of the exposure. And I do that purposely because I have fear that the judge either inadvertently or intentionally will share it with opposing counsel. So I try to keep to the narrative and argue my position, but I don't ever disclose the numbers that I am viewing on the case.
Yeah, I don't as well. I like to put in a bullet point list of future exposure by years. And as a genius negotiating tactic, I always stop it at like 4 years. But I don't know how many cases that's won us. But I don't put in the authority that I requested, because I think that's between us and our clients. Let's assume that we reached a settlement, either in the mediation process or outside of mediation, just in discussion with counsel, or as the people on this meeting know, maybe the adjuster just negotiated a settlement with the claimant or with claimant's counsel, and they didn't have to bother with Rob and Jacqueline and myself until it's time to do what we're doing here, which is preparing the CNR, preparing the settlement documents. Jacqueline, the CNR is a form issued by the Bureau?
Yes, it's a 4-page form that's issued by the Bureau. You can have addendum, so you will often see a CNR being more than 4 pages, but the Bureau form itself is 4 pages. You put down all the terms of the settlement. The form, like all the Bureau forms, includes the claimant's information, the employer's information, the TPA or insurance carrier's information. The form also includes information such as the date of injury, the description of injury, the average weekly wage and compensation rate. But more importantly, it includes the specific terms of the settlement, including any lump sum amounts, the attorney's fee that will be paid, how medical bills are handled. It will discuss how Medicare's interests are taken into account if that's needed. It will discuss issues like child support issues, any third-party lawsuits, reimbursement of litigation costs. So it basically is everything that we've agreed upon on paper. The form is signed by the claimant, claimant's attorney, defense attorney. The form itself does also include lines for the employer or the insurance carrier to sign, but I can only think of one judge that actually requires that signature. And so typically it's just claimant signature, claimant's attorney signature, and the defense attorney.
Where are we at on, I'm making the classic cross-examination mistake of asking a question I don't know the answer to while putting you both on the spot. Witness signatures are now not required. Is that accurate?
That's correct. As of last month, so we're about 30 days into it, you no longer need any witness signatures or the notary. So prior to, I believe it was February 20th, you either needed 2 witness signatures or it to be notarized, and that no longer exists. It just now requires claimant signature, claimant's attorney, and defense attorney.
Yeah, the CNR, after it's drafted, after Jacqueline puts together the CNR, she'll send it to her client and opposing counsel. They may or may not want to negotiate some of the language. With any of our new associates that we're training, I always tell them that if you're settling a case for $100,000, you should be drafting a $100,000 document. Make it worth your settlement, because you don't want to make mistakes. You don't want to spend money that you don't want to spend. We'll get to that in a minute, what mistakes can be made, but make sure that everything is closely reviewed. And I'm going to send it to you, the adjuster or the claims manager, to review it yourself, because I want everybody on the same page before we go into the courtroom. Jacqueline, as part of the CNR, we've long done the child support document submission and discussion. Why do we do that, and how does it work?
Just very briefly, what you need to submit with every CNR agreement is a printout from the Pennsylvania Child Support Lien Search website. That is a website where you put in the claimant's name, the social security number, date of birth, and it does a search as to whether this individual has any outstanding child support orders that need to be taken into account. If a settlement is more than $5,000, any outstanding child support orders must be paid, and they are to be paid out of claimant's share. So not only do we put that in the CNR agreement, but we would also attach the printout from the website to the CNR agreement, along with a child support statement, which is a very, very brief form, but the form says basically the individual's name, date of birth, social security number, address, and then they certify whether they have any child support issues outstanding, and they sign that form. So that is also a requirement.
So once the documents are gathered and signed, they're uploaded in modern day. They're uploaded to the WICAS system in advance of the hearing. We're going back gradually to live hearings. So perhaps we'll return to killing trees and using paper and handing stuff up at the actual hearing. But for now, everything is signed by everyone. We upload it to WICAS. Rob already talked about resignation and general releases. I don't think we need to rehash that. I would say if you need one drafted, talk to Rob, because he's the best there is on it. But as a point of reference, you're not going to upload the resignation or the general release to WICAS. You're not going to hand it up to the judge. You're not going to wave it around in the courtroom and let them see it. I will say, Rob, I don't think that there's a general prohibition on resignation or a hatred of it by all the Southeastern Pennsylvania judges. I think there's a few judges that will question the claimant. Did you sign a resignation letter? But I could identify by name who those judges are, and I think it's less than the majority. Would you agree, Jacqueline?
Yeah, I mean, there's two judges that come to mind that will take issue. Other than that, most judges either completely do not get involved. There's still just only a handful that may ask the question, but they won't take issue with a general release being signed.
I will say just one slight difference, not so much here in the Central District, but in the Western District, there are one or two judges that if there's a resignation letter signed, they want it uploaded and attached to the CNR documents. They have no concern about it. They just want it to be part of the full record.
They are now doubling as employment law Court of Common Pleas judges, which is appreciated by the taxpayer. Mistakes that we try to avoid that we've seen in the past in drafting of the documents, guys? Anything that jumps out?
I try not to copy and paste from prior documents because there's certain language that you want to make sure is included, certainly, but each settlement is slightly different. We might be resolving medical only, it might be resolving indemnity only. It might be an issue where we're leaving a petition open or we're disputing a certain aspect of the diagnosis or treatment. So I take a fair amount of time to make sure that the language is tailored to that case. I also don't allow or leave it for me to dictate and ask a legal secretary to type it into the agreement. I might be a dinosaur, but I still like to sit there and type it myself in the CNR agreement and review it several times before I send it to opposing counsel and to the client for their review and approval too.
Well, you're a dinosaur because you type it on a typewriter, but we still love you. Jacqueline, any
triplicate, but yes. So.
Any mistakes that you can think of in drafting the documents?
It's just, again, going back to the basic principle of not having sufficient information to cover all issues. We don't want to say we're agreeing to all outstanding medicals if we don't know what they are. We don't want to say we're waiving a third-party lawsuit subrogation interest if there is a third-party interest. We just really want to make sure that we have all the information so that our terms of the agreement are most favorable to us. They cover all things that we want and that we know exactly what we're agreeing to.
Awesome. I think piggybacking on that as quickly as possible, there's a comment saying that hope is not a plan. Hope is also not a very good approach to drafting the CNR agreement. If there's an issue that hasn't come up to that point when you're preparing your CNR agreement and you as the carrier or you as the defense attorney, you're hoping that it doesn't come up before the day of the CNR hearing. So we'll push that to the side. Do not do that. It's going to come up, and it's going to come up after the CNR hearing, and it's going to be a pain and a mess to deal with. So as painful as it can be, deal with all these things in the language of your agreement as tactfully and smartly as you can, but don't leave any untied loose ends with the hope that they'll never come back to bite you, because they will. So I think that's good for drafting. Rob, just a minute on the structure of the CNR hearing. When you show up, what's going to happen? What's the judge's role in the room?
Sure. So just very, very quickly, if the claimant's unrepresented, I send the documents to the claimant well in advance, and I review it with them 2 or 3 times, reminding them that I in no way represent them. And then I also put that on the record and who I represent. So the structure is, claimant's counsel, myself, the judge. Some judges will ask a lot of questions of the claimant, and then counsel and I are left with asking the questions that the judge didn't ask. Some judges want the attorneys to ask all the questions. The judge is only looking at whether or not the claimant understands the legal significance. The judge doesn't care if it's a good deal for the claimant or a bad deal for the claimant. They don't care if it's a good or bad deal for the defendant. They just want to make sure that the claimant understands the legal significance, and that's the threshold that needs to be met during the hearing for the judge to approve it.
Jacqueline, any thoughts on the process or any mistakes that you see on the day of CNR hearing?
The mistakes again come up with some information that usually comes from claimant's counsel. Claimant's counsel says to you on the day of, oh hey, I have this outstanding bill, will you pay for it? Things like that are the common mistakes that come up. We want all that resolved before the hearing. But if things like that come up, I think that there's no harm in requesting that the hearing be continued. Jason, like you said, you want everything cleared up. You want to go into that courtroom with all issues resolved.
Yeah, the hearing could be continued for 5 minutes to allow someone to call their client, or the claimant have a sidebar, or us to call the adjuster if that issue comes up. Or if it's something that we can't resolve, I agree. There's little harm in allowing the judge to relist it, and they relist things so quickly now with everything being virtual. It could be the next day in some cases.
Yeah, and with pro se claimants or claimants who are hesitant about the settlement, you want to remove all doubt before the hearing. If it's pro se, for any attorneys on the line, I like to not talk them out of settling, but I ask them every question that I'm concerned they're going to hedge on when the judge asks it. Because I think throughout the state, the judges are going to be protective of a pro se claimant, and they're going to make sure that they really want to do what they're doing. So make sure that to the extent that you have involvement, that the claimant's ready to go and they're not going to waver on questions. Anything else I want to move on. We have a bunch of questions. I want to move on to those. Anything else on the CNR hearing, or what happens on the day of or after, guys?
Well, after, then you do get the decision. Hopefully the judge approves the agreement. So you will get a decision via WICAS or in the mail. Usually the judges issue that pretty quick. Usually it's either the day after the CNR or within a couple of days. And at that point is when the settlement money should be issued. But the settlement monies should not be issued until you actually have the decision.
Yeah, and I always put waiver appeal language in my decision too, that the claimant's waiving the 20-day appeal period. That allows the funds to be issued a little more quickly, because the carrier doesn't have to worry about about an appeal issue.
Yeah, and if it ever comes up with you and your attorney, people on the claim side, you can also waive your right to appeal. I don't usually recommend it. It's very rare that a CNR is appealed by either side. And if it is, it's because something went terribly, horribly wrong. So to give up that right on your end as the defendant to appeal a CNR decision, to me, I don't know what the benefit is. If you want to pay the check early, just pay the check early, especially if the claimant already waived their right to appeal. You can pay it whenever you want to. But as a rite of passage, I don't usually recommend that my clients do it automatically. And when the judges ask me about it, if I haven't had that specific discussion with the client, I'll tell them honestly, I said, Judge, it's not a discussion I have with my client. I can't waive their appeal without their knowledge. And I'll certainly tell them to issue the check tomorrow if they want to close down the wait period. So I think that covers the hearings. I think that covers the documents. We do have some questions, so I'll try to get to those in turn. And I'll bounce back between you guys. So a bunch of questions in the chat. Okay, so it's a question of, if claim is not settled, can you remind me the statute of limitations for how long the claimant can come back for treatment or wages? That's a multi-tiered question. There's a couple different ways we could answer that. If the claim, I'll look at it in this realm. If the claim is not settled, the claimant can come back for wage loss or medical. They can come back for medical for any period of time, essentially. For wage loss, I think if you're suspended for wage loss and it's probably 3 years, and then you get a new claim petition burden. Am I remembering that correctly, guys?
That has been my understanding.
Okay. So yeah, if the claim's not settled, you're going to have a risk there. So you could administratively close out your claim, but if there's no other closure, you don't have a judge's decision for final payment or for full recovery, then you need to be aware that that claim's not resolved. It's not closed out. Is there any recourse for an employer if a CNR is completed with a hypothetical large loss and the employer requests confidentiality from the injured worker, and then they turn around and they blab to all their coworkers that, my employer just gave me this massive workers' comp settlement. Hooray. Rob, employment law question. We put all this terrible, mean, nasty language in saying that confidentiality clause, how enforceable are they?
I don't think on the comp side it's really enforceable. In fact, there are some judges that would make us strike that language. You can enforce confidentiality on the employment waiver side, but on the comp side, that's a problem. And I actually do work with a nice lady that asked that question, so I'll follow up and chat with her some more after today's session.
This is a great question. If an injured worker goes to pick up their equipment on the employer's premises and they're injured while on the premises, is that a compensable work injury? I'll give my thoughts. They'll probably be wrong, and then I'll let you guys gather your thoughts while I'm blabbing. It's going to depend on the scenario. So if an injured worker goes to pick up their equipment on the employer's premises and they've not yet suffered a work injury and they're still an employee, then that would probably be a course and scope. They're probably within the course and scope to pick up their employment for their employer. I assume that's not what the question is asking, but I'll put that to the side. If they're picking up their equipment on the employer's premises while they're out of work for the work injury, I don't love it, but I think you might have some defenses there. If they're picking up their equipment from the employer's premises subsequent to a settlement, so it's a situation we were talking about. We drafted our CNR. One of the issues that popped up was the employee has a tool bag at the workshop, and we agree that 2 weeks after the CNR hearing, the claimant can go pick up the tool bag. I would argue that that's not a compensable work injury. Of course, it could be a premises liability case, which might even be more of a problem. What do you guys? I like that question. What do you guys think about that?
Well, from my perspective, I think it's really fact specific. I depending on the facts, I might make an argument that the individual coming to retrieve their tools because they're no longer working, how is that within the course and scope or furtherance of the employer's affairs? So I think it depends on the case. I would argue in agreement with you that if it's post CNR and they've resigned, there's no employment relationship. But then I guess theoretically that opens a can of worms on the negligence side and not having employer immunity. So I think to the extent you can have those exchanges maybe off property is probably a good idea, but it's not always practical.
Jacqueline, anything else?
I mean, I would just add if it's before you get to the point where you had a CNR agreement, maybe you just throw in some extra money and you include language in there that it includes any and all alleged injuries, including the one that occurred when you got to the premise. I mean, it might be a cheaper way to get out of the claim than anything else.
Yeah, just avoid the issue if you can. That's good advice. We have a question. Will the board, I think in this situation, we're talking about the adjudicating judge, will the judge accept model language from CMS regarding the MSA as an exhibit with the CNR agreement? So can I attach CMS instructions to claimants as to how the money is supposed to be invested, how it's supposed to be put into savings and spent, and that sort of thing? In Eastern Pennsylvania, Jacqueline, you can disagree. I've not had judges have a problem with that.
I agree.
I do that not every time, but a lot of the time. If it's documentation that I think makes it clear what the claimant needs to do, then we'll attach it. And I haven't had a judge say no. Rob, is that your practice?
I typically attach it. I think it's especially if it's been provided by CMS in a packet with the determination. I think it's all part of the packet. So I tend to include it. I also not specifically ask, but if there's a mechanism that the MSA is funded by annuity, the annuity companies typically have language that they want to see in the agreement as well, as it relates to the seed money and then the annual payments if living. So I tend to I try to incorporate that language and not necessarily add it as an addendum for fear that it gets lost. But yeah, I put that language in as well. I don't have issue though with adding the model language from CMS.
And from the Q&A questions, I don't know if everybody can see these or not, so I read them. The first one I have is it's about Medicare. And again, we're gonna do the 200 level class on Medicare. It's gonna be fun. But this one is, and this is a very reasonable, fair question. Is there a specific time period prior to the 65th birthday when you need to start considering Medicare's interest? Is there a drop dead, 64 years and 6 months, that sort of thing? Guys, do you have an age which you use, or are there other factors that you look at?
For me, I tend to look at whether or not claimant's receiving Social Security disability benefits or has applied, because that can be a trigger for the 30-month enrollment in Medicare in some cases. I also try not to play fast with the rules with Medicare. So I don't settle the case for $24,900. That makes me nervous, especially if there happens to be other bills that are paid and then or lit costs, and it puts us over the threshold. So to the extent that there's ever any concern with Medicare eligibility, I start with opposing counsel, and then I go to the carrier, because they can certainly check the Medicare rules on their end as well, and try to be as cautious as possible, because my license is important and I don't want to anger Medicare. Yeah,
and Jacqueline, see what you think about what I say and correct me. I look at Medicare set-asides as a ask permission, beg forgiveness situation. You can, and the clients will say, do I need to, CMS isn't going to review this. Do I need to care about, Medicare? No, you don't need to. I can't force you to do anything. And I can't tell you that CMS is ever going to enforce, payments or secondary payment obligations, but I can't tell you that they're not. So it's a comfort thing. A lot of our larger clients have policies, because Medicare is obviously not state specific. So they might have policies that maybe 64 years, 6 months, they always want to do a Medicare set aside. And I'm okay with that too. But I think you just need to, when it becomes an issue, everybody needs to be in agreement about how you're going to advance. And if you're going to take the route of begging forgiveness, just know that that's a potential that's out there for the future. Is that in line with what you think?
Absolutely. And so I think what was important from what Rob said is that it's not just age specific for Medicare. Someone could be 35 years old and be a Medicare recipient. And so that's why you do want to look beyond the age. The age is just one consideration. If someone is receiving Social Security disability benefits, you want to take a close look, because sometimes the date back to when they actually started receiving them can be, those 30 months can be eaten up really fast. And so that's why you look for the Social Security disability status as a starting point, and then you go from there.
Okay. 2 more questions. I'm going to take them out of turn. I'll take a stab at the last one first. What's the best way to resolve a claim with a pro se claimant? I'm going to give my approach in general and see if you guys have anything different. The best way to resolve a case with a pro se claimant, offer them as little money as possible. No, I think what I always recommend when an adjuster says, hey, I got this case with pro se claimant, as long as we're not in litigation, I like the adjuster to make the approach there, assuming they're comfortable doing so, and make that initial offer. Because if it's somebody that's just been getting their workers' comp benefits, they've not been in litigation, they've not dealt with Chartwell or Rob or Jacqueline or myself, when they get a call from an attorney, as would most people, their first thought is, well, maybe I need to get an attorney. Whereas if they're getting a call from a claims adjuster that they've dealt with, for several months or years, they might be more comfortable considering what you're putting out there. So number one, if they're comfortable, I would have the claims adjuster make the first contact on that. Number two, and it's kind of contrary to what I recommended, know your claimant, but I wouldn't try to undersell them. I would offer something that's fair, that if you were the injured worker and you got that offer, you'd say, well, that seems like a lot of money. That seems reasonable. So maybe you offer a year just to close it out. If you offer 5 weeks, maybe they'll take 5 weeks, but maybe they'll also go straight to an attorney and you'll get a 5-year demand in response. Guys, any advice on pro se claimants beyond that?
That was perfect.
Yep, no, I agree. Again, I just like to document, especially if the adjuster has negotiated the settlement. I send a letter confirming the terms as I understand it and reiterating that I don't represent the claimant. In full candor, I tell them they have the opportunity to obtain counsel, but if they ask the question, I tell them, in all honesty, that they're going to, if the attorney settles the case, they're going to pay 20% on whatever the negotiated amount is and leave it at that.
Yeah, good points. Last question about, we've mentioned supersedious. Supersedious fund recovery, what's the turnaround time for a decision and issuance of the check? That's a fantastic question that the answer changes on a yearly basis. I think the quick and painful answer is longer than you think. Whatever you think the turnaround time should be, it's going to be longer than that. The decisions take a lot longer, assuming that you're okay with the decisions. The decision's going to take a lot longer than getting the check. Assuming the Commonwealth doesn't have funding problems, they'll usually get the check out within 6 weeks-ish. It used to be I'd tell my client ballpark at least a year to get a response from the supersedious fund on their decision on your application. I've seen that a little quicker recently. It's going to depend on your case, how complicated it is, how many payment ledgers you upload. The only thing, if you're handling supersedious applications yourself, the only thing I would recommend is overshare. Give them everything you could think they could possibly want, because if you don't, that's just going to extend your time frame. If it's a situation where there's a CNR involved, you settled future exposure and you're seeking supersedious reimbursement for past exposure, just upload the CNR. As long as you wrote it the right way, there's nothing to hide, and that's going to explain to them right up front, this is the situation here. Please give me my money. Any disagreement on the timeframes here, guys?
I would say that a year is kind of generous. I think it's going to take a little bit longer. I had one, unfortunately, that I just received in the past month, and it took us 2 years to get it. So it happens. It takes a while. It's just unfortunate. And so that's sometimes something to consider when you're making that decision. I think it's a good tool, but it could take a while.
Yeah, you're not going to lose any money with the delay. There's no time frames to file the application within. There's no time frames for them to respond, unfortunately. So your potential recovery does not change, but you also don't get interest. So we recognize that it's money that you've added into your calculations that you unfortunately have to wait on. Rob, any supersedious fun facts or information?
I think the timing of recovery depends where you are in line in the year. If you submit your application and there's still funds before the next assessment, you probably are going to get paid pretty quickly, get reimbursed pretty quickly. But I have approvals that were submitted last December, and I'm getting letters telling me that it's not going to be paid until the second or third quarter of this year because of the assessment issue. So I think it depends on that. And honestly, as you said, I think it depends on the complexity of the application and in some cases the amount that you're requesting, because if it's a large amount, they're going to maybe pay a little more scrutiny to the application.
Awesome. I don't see any other questions, so I think we ripped through everything pretty good. It was great to have everybody here. We really appreciate all the turnout we've had throughout the 101 seminars. And thank you, Rob. Thank you, Jacqueline, for participating.
Thank you.
I'm going to force you to do it again, so you'll be in the 200 series. But always good, always fun, and thank you everybody for being here.
Thanks. Take care, everyone.
Have a good day.